Okay, so our code of conduct, if you would like to read it in full detail, it is located on our website, and it's txla.org/code of conduct. So a few happenings at TLA. We are so excited to share with you that registration is now open for our annual conference. It is held in San Antonio this year, April 16th through 19th. So if you have not registered, please make sure you get that early bird pricing and go ahead and register. You get that pricing up until January 31st. Also, if you have not renewed your TLA membership, we strongly encourage you to do so. You are attending a college and university library division session, and so it is a great way to support this division and make sure you select that with your membership. A few cool things happening at TLA. We are hosting a series of meetings throughout the state that are discussing digital conversations. And with all the broadband access that is coming down from our federal government, we have subject matter experts hosting a panel conversation in different regions. And so we encourage you, the next one coming up is on the 10th in Victoria. And we do have a few more coming in the new year in the El Paso region, in the Wichita Falls region, and also in East Texas. So keep an eye out for that. I know it's the season where you guys want to cozy up at home. It is cold outside, but it's also a great season to get your CE. So if you have not checked out our self-paced learning, please go ahead, scan that QR code or look on our website, and you can get your CE at the comfort of your own home. And now I am so excited to introduce David Baca, the chair of the College and University Libraries Division, as he introduces our incredible speakers for today. David.
Thank you, Kelly. Appreciate it. Welcome, everybody. I am super happy you guys are here. We've got a really good session for today. Today we have Ann Gilliland, the Scholarly Communications Officer for the University Libraries. She's an attorney and a librarian who has worked at University of North Carolina, Chapel Hill since 2012. She provides information and guidance to the campus community on copyright and fair use, authors' rights and publication agreements, open access, privacy, and related issues. Before coming to UNC, Ann worked for the Ohio State University, the Ohio Library and Information Network, and several other academic libraries. She holds an MS in Library and Information Science from the University of Tennessee and a JD from Capital University. Kevin Smith is the Michael and Eugenia Wormser Director of Libraries at Colby College. Prior to moving to Colby, he was Dean of Libraries at the University of Kansas, where he also taught copyright law in the KU School of Law and served briefly as interim director of the University Press of Kansas. He became Dean at KU after 10 years as Director of Copyright and Scholarly Communications at the Duke University Libraries. As both a librarian and a lawyer specializing in intellectual property issues, Kevin frequently advises faculty, staff, and students about the impact of copyright, licensing, and the changing nature of scholarly publishing in higher education. He is the author of numerous articles on the impact of copyright law and the internet on scholarly research, as well as libraries' role in the academy, and his book, Coaching Copyright, co-edited with Aaron Ellis, was released by the American Library Association in the spring of 2019. Both Kevin and Ann will be presenting. If you have questions, you can put them into the chat. We will get to them at the end of the presentation. And then if we have an interest, we may split up into breakout rooms as well. So now I would like to turn it over to Kevin and Ann. Thank you.
Thank you very much. You didn't, because I didn't give you the list of my degrees, but my law degree is also from Capital University. Ann and I went to the same program in serial. I think, Ann, we may have overlapped by a year, but not more than that.
Yeah, I think it was, you were leaving and I was going.
I think that's right. I am going to share my screen. so that we can get started. Is that working? Do you all see my screen? Okay, great.
Yes.
Thank you.
Yes, you're fine.
Thank you. So I don't know what more introductory remarks we have, Anne.
I think they've got the formal and the informal, and
I think so.
we can
All
get
right.
going.
All right, so let's get going. Let me make sure I know how to advance the slides. And I'm going to get started. We're going to, I'm going to start, hand it off to Anne. She's going to hand it back to me, and I'm going to hand it back to Anne at the end of the presentation. So that's the order of the run of show, as it were. So the first thing we need to say about copyright and generative AI is that it's really complicated. Generative AI itself is a complex set of systems and functions. It's much too simple to say generative AI is, because there are multiple different models that are based on multiple different technologies. The way they're trained is different, and the way they produce output is different. On top of that, of course, copyright is a complex body of law, which I imagine you all already know. So when you put them together, you have a situation where it is very difficult to define specific answers or even what the questions are about copyright and AI. And then it's just very early days. These developments happen very quick. I mean, they've been going on for a long time, but they hit the public eye very recently. So a lot is changing. And I was saying before we started that this past week, while Anne and I were trying to finalize our presentation, a court ruled in a very early in a motion to dismiss, but it's a significant ruling in one of the cases that challenges, it's brought by artists challenging the use of their work in the training data for a particular AI model. And the White House issued an executive order on artificial intelligence. So it really is changing from day to day. The only other thing I wanted to say here is that there's been a little debate that I've seen about whether or not what we're talking about when we talk about AI. Is it just more computer capacity, bigger data sets, more computer power? Is it just traditional computing, bigger and stronger? Or is there something significantly different? And I just want to say up front, I think there is something significantly different. And what that something is the process by which training data is turned into a neural net, this set of parameters that helps the model, however the model creates output, it uses this set of, and in the larger models, it's billions of parameters. Those parameters are what generate randomness, why the computer doesn't always say the same thing when you ask it the same thing. And that, I think, is a significant change, and I think it's a change, as we'll see, that's relevant to copyright questions. So we're going to talk about the artificial intelligence supply chain. This is language we get from an article by Catherine Lee, A. Feder Cooper, and James Grimmelman called Talking About AI Generation, Copyright and the Generative AI Supply Chain. What the supply chain does is sort of pulls out the different elements that go into the creation and then the use of an AI model. And looking at that supply chain, first of all, emphasizes how complex these models are, and it identifies different steps at which we have to ask different kinds of copyright questions. And at this point, the other thing I want to say is that the design of a particular AI model matters a lot in how we address copyright questions. A long time ago, the copyright professor and now Harvard professor of law and politics, I think, Lawrence Lessig, wrote a book called Code and Other Laws of Cyberspace. And Lessig really brought our attention to the different ways in which we regulate social behavior. Law is only one of them. I have listed here 4 that Lessig identifies. We regulate behavior through law, through social norms, through markets. You don't want people to smoke, make cigarettes more expensive. And through architecture, and that's what Lessig meant by code as a law of cyberspace. The way these models are built, and the way they're built differs quite a lot sometimes. The way they're built has a definite impact both on what the copyright questions are and what the potential answers will be. So I hope at this point I have convinced you that this really is complicated. I'm going to just get a start on on what we mean when we talk about this supply chain, and then I'll turn it over to Anne. So where we start, when we start, I don't train generative AI models, but forgive the we, it's kind of a royal we. Where we start is with original data, which may or may not be copyrighted. Of course, data can mean a whole lot of things, and in AI, it absolutely does mean a whole lot of different things. And in one data set, there is going to be material that is public domain, material that is not subject to copyright, and material that is protected by copyright. So that's just the first complication. Then individuals and companies put together data sets, often data sets that they either sell or otherwise make available for the training of large language models, which is what lies behind these AI models. There is one called, I never know how to pronounce it, it's L-A-I-O-N, Layon or Lion, but it stands for Large Scale Artificial Intelligence Open Network. And that is a massive set of data that's been scraped from the web and constructed in other ways. We know it lies behind the training of ChatGPT and Stable Diffusion because I think that's been brought out in some court cases. So assembling this collection of data may result in another copyright because there's a compilation copyright even when underlying items, data points, are not protectable. And the construction of these data sets is not a one-time process. It's iterative. It happens over and over again. So things may be added that change the complexion in terms of copyright. The next step, or it's actually a much later step, a user may enter a prompt that is protected by copyright or actually may use protected material as a prompt. So another stage where there are copyright issues. And then there are some systems that actually search the internet in real time, gather more information depending on what they're asked, what the prompt is. And that becomes an uncontrolled input that is based on the output. And that's one more layer of copyright problems that are created here. So that's, as I say, the beginning of the supply chain. And Anne is going to talk to us about some of the next steps.
Yeah, a few more complications. So there are a lot of places in the supply chain where, as you've seen a bit, copyrighted material can be introduced, and that there can be, in theory at least, a copyright infringement. Places where somebody else's copyrighted content could be displayed, reproduced, performed, and so on, or even in some cases a derivative work made in some way. And this slide just lists a few of those places. There are many, and in many permutations. So the initial data may be copyrighted. It does seem pretty clear that at least some of the big AI models that are publicly available includes some data that has been misappropriated. That came from infringing torrent feeds. There's a data set called the Books 3 data set that includes a lot of full text of popular books that has been used for training, it appears, without permission from the rights holders. So you start with this combination of things that may be in the public domain, may be in copyright, and like so much of the stuff on the internet, in some cases we don't even really know. Once a training data set is assembled, there may be a copyright in the compilation. For some of you who are more of the copyright nerds in the audience, it's possible to have a copyright in the way you have put together a group of things, anything from a database to a phone book to an AI training data set. And so somebody, it's not always clear who, may own a copyright in that data set. As those data sets are transformed into models that are used more closely to the end user, there may be additional copyrights. There may be a derivative work created. There's going to be more curation, and there are, I think, at least the possibility that you could have a new copyright coming out of that material. Another thing to think about is that this is not a situation where you have rights holders for the initial data, and then you have this company that has done all these other things. There may be many companies, as well as many individuals who have hands on different parts, or whatever you want to call them, who work with the data at different parts of the supply chain. Once the model is trained and is being used, the platforms that are used for more or less the end user of the product may be infringing the rights of public display or performance, depending on many of the factors above, including whether the work was in copyright before or not, whether it is a fair use. And there are just many possibilities. And that, of course, is one of the things that makes tracing the through line of copyright ownership and infringement so difficult in this situation. And then there's the question of who owns the content that is generated. Is it the person who entered the prompt? Is it, or are they the companies that compiled the material? Could it be all the previous rights holders? It's really not at all point. And there is also, like, perhaps a potential court ruling that because a generated AI output is created by a machine, that, as the Copyright Office says, you've got to be a human to create something that can be copyrighted. So these are all issues that are up for grabs right now. Definitely. So one of the things that occurs to us as we puzzle over these, very complex and shifting landscape is this the most important thing that's happening with AI right now? There are a lot of issues. And if you are like me, what I have done when it comes to issues about what a lot of people on the internet would call AI safety, I've been like, la la la, I can't hear you, because it seems very frightening, and it seems like something I can't do anything about. But I'm beginning to think that, I've tried to keep my anxiety under control, but I've got to start thinking about some of these issues that are probably more important. Some of the privacy issues involved with the use and training of these models and generations, the rights of publicity of people whose pictures and other I want to say detritus, but that's not the right word. Things that involve their public personas that have maybe been used without permission. Plagiarism and integrity problems. There's huge concern about how do I know who wrote this? How do I know where it came from? And then there are also a lot of questions around what AI is going to do to the economy. We'll talk about this a little bit more later, but we had a speaker who came to the library who teaches at the business school, is an AI specialist, who basically said, hi, AI is going to make all of you guys obsolete. And although we've all heard these things before, I think there will be a period of adjustment that will take place in many professions, careers, businesses, and some people will make out very well, and maybe some people will not. There are also a lot of issues that I think are concerning national leaders and national companies about, are we going to stay on top of this? And what will be our position if other countries get ahead of us? Some of them maybe not things to worry about so much, but others kind of are. So attribution, when I talk to faculty about AI, they are really worried about the attribution problem. And it is a problem that a lot of times faculty will say to me, well, is this something where AI just can't do it at all, or they just don't want to? And I think you can see how we treat AI as a person, and maybe not a very nice person a lot of times. But aside from whether AI is a person, the answer to that question is a little bit of both. The size of the data sets is one of the reasons it's so hard to attach attribution. A lot of times the data that has been used for training doesn't have attribution. I mean, just think of all the pictures you see on the internet that somebody took or somebody created, but you can't tell who from simply looking at the website in front of you. And also the chain of similarity can be really hard to trace. So, for example, it may be that one of those books that was misappropriated as training data formed part of the generation that somebody is now looking at and working with, but tracing that back may be difficult or impossible sometimes. When I'm talking with faculty and researchers, especially in biomed, they are often very concerned about, how do I test an AI generation? So let's say they use generative AI to come up with new formulas, drug formulas, or to identify new patterns that are indicative of a malignancy, things like that. They know how to test those things. They may have to do a good bit of work still once they have the AI generation, but they can start to try to figure out, is this really something reliable? In some cases, that is relatively easy. In other cases, especially ones that involve matters of fact that can't easily be proven or disproven, it's a little bit harder. One expert who I heard speak said that the thing to do with AI generation is to think of it as a weather report. And this guy said, well, if the weatherman says it's not going to rain and it does rain, well, nobody's upset. They didn't know, although he doesn't live in the world I live in, because lots of people get upset when the weather report is wrong. But I think that this level of unreliability is really hard for us to deal with, very difficult for us. And then the safety issue is also there, which is will AI destroy the world and outsmart us all? Will AI be used to mislead us? The answer is absolutely, and it already has, and it will continue in some ways. Additionally, some rights holders, especially of image content, have begun introducing material in the files they post on the internet that poison the data for the purposes of AI training, so that the image looks fine to you and me, but it leads to misleading results and a sort of foiling of the purpose of harvesting it for AI purposes. And I expect that those types of ways to get around an AI, I want to say vacuuming up an AI system ingesting data, they're just going to continue. So there is a lot of litigation and legislation going on all over the place about AI. Some of it based on, I think, realism. Some of it maybe not so much. Some of these court cases may shape what we are in the short term or the long term able to do with some of the public AI services. We have in the US, I think, a law about copyright in AI that is very much in its infancy. The EU has put some more safeguards in place, but it's not clear whether those early safeguards will be ones that will be usable long term. I think there's just an awful lot of unknowns. And so we see court cases and we see legislative proposals that are intended to ease restrictions on the use of AI, and we also see ones that are intended to lock it down more, as it were. I think that the issues around integrity and reliability are extremely pressing. As I said before, I see it the most with biomed faculty and researchers right now, but they are still of great concern for other parts of the academy, people dealing with journalism, with political science, and probably just, with everybody and everything. It is a really new world in a lot of ways. Take it away, Kevin. Are you next, or am I? Yeah.
Sorry, I was muted, but I think this one's yours, Anne, but
Okay,
either
yeah, yeah. And my main point here was not to run us through every case, because it's like mushrooms, but just to show you that they just keep coming. Major authors have filed suit against AI companies. The Authors Guild has filed suit against OpenAI. There are suits against companies that work with music and AI that are in process. One of the things I wanted you to see here is that as with a lot of copyright litigation, you see activity on the coasts. So traditionally, although there's plenty of examples to the contrary, the circuits on the West Coast are more favorable towards the tech companies, and those on the East Coast towards the publishing industry. But there's, I think, no guarantee about how these suits will go at this point. Fittingly, the music lawsuit that I chose is being litigated in the Middle District of Tennessee, which is where Nashville is, you know, home for a lot of songwriters, a lot of music producers. And so a venue that's often looks very favorably on rights holders. And of course, the likelihood that all of these cases will have the same outcome is low. And I would expect it's a pretty easy prediction that there will be a good bit of activity in the appeals courts and maybe even in the Supreme Court as a result of
So
these various suits.
it's going to be years before we
Mhm.
know any real results for most of these.
And you know, I think it's possible that a lot of things will be more or less settled before the cases play out. You know, just as that happened with you know, peer-to-peer file sharing, for example.
Yes. Yeah.
The VCR recording.
Yeah.
It's
Yes,
sort
by
of
the
like,
time the courts finish the process, basically the markets have solved the issue.
yeah,
I think that's an excellent point. I was just going to also point out here, in case people don't know, OpenAI is the company behind ChatGPT, as well as a product called Copilot, which helps write code, computer code, and is also the subject of a lawsuit. Maybe that one's up here.
yeah. Um, no, I didn't put that one up here because it seems to be they've had some dismissal issues.
Yeah.
And but there's plenty more where all these came from.
Indeed.
And if I assume we're going to distribute the file, all the links for these cases go to the court listener dockets, so that if you want to follow the case, which I realize that I want to do, but maybe not all of you do, but if you do, you can do so from a freely accessible website. At the same time, some companies have realized that users are a little bit worried about using generative AI tools, with the worry that, you know, well, I used AI to put together these images for an advertising campaign, but now I'm afraid that maybe I'll get swept up in a lawsuit. And so some companies that offer AI tools are also offering indemnification for the users, meaning if you use our tools and you get sued, we will defend you. And of course, they mostly work, the ones that are offering indemnity work within a more sort of constrained world. So they're not promising this for every single AI generation done on the open web. They're using that assurance within the model of a set of images that they own or have licensed.
All right, I think it's over to me now.
It's over to you.
So I'm going to talk a little bit about the questions that arise for both input in generative AI models and output. And that's very much a simplification of the supply chain. And I think we've already shown that to you, but it's a convenient way to think about what we're talking about. And just following up on what Anne said, several court cases, more than she listed, are pending where writers and artists assert that using their works as training data is an infringement. I think actually that's the core claim in all of the ones that you listed, Anne. That is, just putting it in the data and feeding it to the machine, if you will, is an infringement. I've expressed the opinion here that in the US, there's a good chance that this is fair use. And I based that on the previous cases. We have other cases in the US that are about what we often call non-consumptive uses. That is, uses that don't use any copyrighted material for the purpose that it was intended. The use isn't to read the book, enjoy the painting, listen to the music. The use is something else, and it creates something that does not compete in the market with the original. In those circumstances, we have cases, the Hathi Trust case and the Google Books case, both found that large collections of data, the 16, $18 million corpus of books that was digital books that was generated by the Google Books project, for example, that those can be assembled and used in non-consumptive ways, and the courts have found that that is fair use. Now, of course, the people who are bringing these suits know about those cases, and they are arguing vigorously that this is different. But at the moment, I think there's a good chance that fair use could cover some of this use. You notice how much I'm qualifying what I'm saying? And also that we may not get there. And I'll tell you why in a moment when we look at the recent ruling on a motion to dismiss one of these cases. I think that shows us why it's unlikely that we'll actually get to merits, that what we would call merits decisions on, okay, is there actually infringement here, or is it fair use? The other thing about input is that many countries, and this has been introduced in the United States, it's moved much farther along, and I think Anne implied this, it's moved much farther along in the European Union. But they're considering laws that would require transparency, which means you'd have to say this is the data that went into the training. One of the problems is, at what level do you have to say that? Do you say it's that Lyon data set, or do you have to say each individual item of the tens of millions, hundreds of millions, or billions of pieces of data? Do you have to name them all? That would make training large language models almost impossible. So we have to know what level of specificity these transparency laws would require. And then the other one is demands for compensation, that the rights holders should be compensated. How do you do that? One suggestion is collection agencies, or what we would call a mechanical license, like we have for composers and music publishers in the United States, where there's a specified amount that you have to pay for each item that you use, and it's minuscule, and then that's collected and distributed to publishers and composers. But what ASCAP or BMI does is almost simple compared to what the process of managing compensation for large language model training
Yeah.
would be.
And I bet you those systems will leave someone to scoop up the money on the table that, where there's no identifiable rights holder, which of course is happening with the music too, I think.
Right.
And I just wonder who's going to get that money. I think it will be whatever middleman organization is set up in those situations.
Yeah.
You can tell how I feel about collective licensing, although they are convenient. They're super convenient.
I totally agree with you. And of course, the larger the data set is, and really the catalog of ASCAP is tiny compared to the size of the data sets being used to train ChatGPT, the bigger the data set gets, the more of that surplus money there's going to be, and the harder it's going to be to distribute it to anyone. So these proposals around transparency and compensation, my own opinion is they are politically satisfying. People say, yes, we should do that. And they're incredibly impractical, which has not always stopped especially the EU from passing regulations. And I'll mention in that context a couple of these input issues, these issues about things that are used to train large language or AI models. One is in many countries, in all countries that are members of the World Intellectual Property Organization or the World Trade Organization, there is a rule in our international copyright treaties called the three-step test. The three-step test says that for exceptions to copyright protection, those protections have to meet. It's not actually put this way in the law, it's a single sentence, but it's broken out into three criteria that exceptions have to meet. They have to apply to certain special cases. Those cases cannot conflict with the normal exploitation, whatever that means, of a copyrighted work. And those special cases should not unreasonably prejudice the legitimate interests of the author or creator. If fair use probably doesn't meet the three-step test, but it pre-existed the three-step test, and nobody has really ever challenged it as not complying with this international obligation. And in fact, if anything, we see more countries interested in adopting fair use like, or at least they were before AI became a thing, more interested in adopting fair use style exceptions into their law. But the three-step test is potentially an obstacle for any kind of exception that would be built into the law that would make training data, training a generative AI model easier. On the other hand, this is the last point there, AI may simply overwhelm the three-step test. In fact, I would argue that an awful lot of digital technology has already overwhelmed some of these really specific rules about how we can build exceptions to our copyright laws. Another issue for input, just sort of thinking about things socially rather than legally, most AI training data is in English. And especially text-based generative AI models will continue to build on the hegemony of English in a lot of technology. So I think there are some negative social implications there. And then the last thing I wanted to say here is that the potential outcome of these lawsuits, if we're really, or this legislation, if we're really told that we have to name every item of data or every, sort of discrete data set that is used to train a model, and that we have to compensate all of the rights holders, that becomes such a huge job that what happens is we'll narrow down the data sets. The data sets will get more specific, smaller, and what that does is introduce the greater likelihood of bias and error. The smaller the data set, the more likely it is to make mistakes, to hallucinate, as we say about generative AI. And the more likely those errors that we already know exist in things like Google, those algorithmic biases, are just more likely to occur. The benefit of really large training data sets is that it actually does help filter out some of the error and some of the bias. And I'll say more about that when we talk about output. I didn't know I'd push that button. Yes, we're in the right place, aren't we? Yeah. Sorry about that. So a few pictures for you. This gets to the question of, can artificial intelligence generated works be protected by copyright? And as Anne has already indicated, in the US and most other countries so far, the answer has been no. That is the output of a pure, the output that is created entirely by a generative AI model is generally not protected by copyright. And we have one example that was a court decision here in the United States. That's Thaler versus Perlmutter. Perlmutter is the registrar of copyright. And this year, a district court affirmed the Copyright Office's denial of copyright for this particular AI-generated image. In other words, the Copyright Office said, no, we won't protect AI-generated materials. The person behind it, the person who programmed the computer and who argued that he put in multiple iterations of the prompt in order to get a picture that he was satisfied with, and therefore argued that he should have a copyright, was told no by the Copyright Office, and the district court affirmed that denial. I put this other one in partly because you probably all know about the monkey selfie cases where, or case, where this monkey and a couple of others took pictures of themselves with camera equipment that a photographer had left sitting unattended. And the photographer, Christopher Slater, tried to claim copyright, and PETA, People for the Ethical Treatment of Animals, on behalf of this macaw monkey, who they named Neruda, brought a lawsuit claiming that Neruda should own the copyright in the photograph that he, I think, took. And again, in this case, it's a court of appeals, that it went up to the Ninth Circuit Court of Appeals, and they ruled that a non-human author cannot hold copyright. And that was actually cited in the Thaler versus Perlmutter case as a precedent for this rule that things that don't have human authors. And I always think that makes a certain amount of sense because copyright is human law. We impose it on ourselves as a society, and do we really have the right to impose it beyond the limits of human society? But that's an argument about Neruda. It may not be an argument about the products of generative AI. But that's where we stand right now. I do want to point out, though, a little why I have some discomfort with this idea that the products of generative AI cannot be protected by copyright. And that goes all the way back to why we protect photography. In 1884, the Supreme Court ruled in a case that involved the photograph that you see there, a photograph of the Irish writer Oscar Wilde, taken by a New York studio photographer, one of the early paparazzi of his time. His name was Napoleon Cerrone. He took this photograph. It was used by others without Cerrone's permission. He sued the defendants, defended by saying, this is the product of a machine. There's no human author here. It's just a machine making this picture of whatever is put in front of it. So therefore, they said there was no copyright. That sounds really familiar. It sounds very like the arguments made about generative AI. But the Supreme Court found that the photograph represented a series of creative choices made by a human being. What Oscar is wearing, the drapery around him, the scenery in the background, the lighting, the exposure, all of those are decisions that controlled what the final product looked like. So the question I have is, if this is, and it's very strong precedent in the United States, this is absolutely settled law if ever there was. If ever there was, there's a qualification. Is there a point where the human person who creates the prompts has enough control over the output that we ought to start considering it a work of human authorship? Now, the argument the Copyright Office has made, and this is why I began with something early on, is that there's a level of randomness in generative AI that doesn't exist between the photographer and the camera. The camera pretty much gives the photographer what the photographer has asked for. But with generative AI, you can ask it the same thing multiple times and get different results every time. So this randomness may be what distinguishes photography, which is protected by copyright, from the images and text and everything else that is the product of a generative AI model, which is not currently protected by copyright. And then I close with the question that I have no answer to. What if we can't distinguish between human and AI creation? How is the Copyright Office, for example, going to know? They depend on an honest um, disclosure of how a work was created. And as AI gets more and more sophisticated, it will be harder and harder to distinguish, and therefore easier and easier to make false claims.
But Kevin, I always think about this and think about um, randomness is part of a lot of creative acts. It plays a part in visual art, creation of visual art, of at least in avant-garde texts that are created, and it seems like there isn't any great move to nullify those copyrights on the basis of randomness.
Interesting. So it
I
may
bet,
just be
yeah,
it may just be a degree of randomness, is what you're suggesting.
yeah, or how in your face the randomness is.
That's
Yeah.
interesting. That's interesting. Yeah, I mean, obviously, in case our audience hasn't figured this out yet, we don't have any answers here for the very good reason that there are no answers to any of the questions, I would argue. In fact, the one about not protecting the products of generative AI is just about the closest thing to a settled rule that we have, but we know it's going to be challenged. It's already being challenged multiple times, and there's going to be inevitable qualifications around it. So that's a great point. Um, the next set of questions revolves around the output, and I've already really begun to talk about these, the output of an AI program and how that's related to the training data. It is possible, I'll start there even though it undercuts some of my argument, it is possible in certain situations to ask a generative AI model to give you something based on a prompt, and it will give you something that inevitably has to be very similar to what it was trained on. And I call this the Snoopy problem because that's the most obvious one. Even if you use a huge data set, and these things do, images that's scraped from the web, for example, images of Snoopy are almost always the same. Snoopy always looks alike, looks the same. So if you then, no matter how many images, usually a large database, prevents you from getting the same results over and over again. But if you ask it for a picture of Snoopy, it's going to look a lot like, well, Snoopy. So that's an example where the image is so often the same, so distinctive, always associated with a particular name, where the output of a prompt that says, give me a picture of Snoopy flying a World War II airplane, will get you a very familiar picture, and it may look a lot like something that was used or multiple things that were used in the training data. In general, I think there's a great debate about whether or not AI programs, this is the language they use, memorize training data. And in the resources, Anne has listed two articles, one by Matthew Sagg and one by James Grimmelman, who's a law professor, and two computer scientists, that come to exactly opposite conclusions on this issue. Sagg says that AI programs do not memorize, and it's his opinion that's expressed on this slide. Grimmelman and his colleagues use that language throughout their article. That the question is, we know that these models can't possibly save, compressed versions of all of the material that's fed to them. But do they save compressed versions of something? And then what does it mean to memorize? If you put in, and I've seen, in fact, in the Grimmelman article, they do this, they show images where a particular name and some other information is used in a prompt, and they get an image of a well-known person that is very similar to an image that's easily found on the internet. And they argue that that means that the model has memorized that picture, and therefore you have a very clear example of infringement. You have the image used in the training data and the output image, which is substantially similar, which is our standard for infringement. The question to me is what we mean by memorize. I actually posed this to an AI expert on our campus yesterday. I asked her, is it possible that the image, what happens is that these images are turned into a series of relationships that that we call parameters that make up the neural network of an AI model. Is it possible that that if the prompt is specific enough, those parameters would actually produce a similar image without the original being, quote, memorized in the actual model? And her answer was ambivalent. So what we mean by memorize will be an issue in these cases. And that's the other thing I'm going to say about this slide. These pending lawsuits. One of them, as we told you at the beginning, one of them there was a ruling on a motion to dismiss 3 days ago, I think 4 days ago, very recently. In that case, it was exactly this question: is the output of a particular AI model? This was the image generator model called Stable Diffusion. Is the output, are they derivative works of images that were used in the training data? Really interesting question. The claim that was made by the plaintiffs was extremely broad, which was that we know that some of our clients' images were used in the training data. How do we know that? Well, because we think it's part of this data set. It was that Leon that I mentioned. We think they're part of this data set, and we know this data set was used. In any case, we think we know that our plaintiff's images were used in this training data, and therefore everything that comes out is a derivative work from our clients' works. Frankly, it's a ridiculously broad claim. And this past week, the judge dismissed most of the plaintiff's claims, but he did so with leave to amend. In other words, they can rewrite the claims and refile the case. And what he has asked them to do is Ann mentioned this, draw that line between something that is in the data set, identify it specifically, and then show that some output is possible that is substantially similar. That's the normal way that we would show infringement in copyright cases. The problem is, as Ann indicated, it's virtually impossible here. It's just, how would you do that? They don't really know for sure which images are in the training set and producing something that is substantially similar. And when the judge said that, he was rejecting this idea that everything is a derivative work. You have to show some similarity for something to be a derivative work. He set a perfectly appropriate but impossible to meet standard for those plaintiffs, in my opinion. So that's going to be interesting to follow, whether or not the judge even admitted that it was unlikely that the plaintiffs would be able to refile a complaint that would meet the standards he was setting for them. We'll see if other cases follow that, but it's a really interesting direction. I better stop talking about that. Policy proposals, Ann talked about these. Policy proposals around transparency. Companies would have to reveal the training data, and I think I brought up the question of what level of specificity. Compensation, what would that look like? Would we be creating another one of those thoroughly corrupt collection agencies of which Ann is so suspicious, and rightly so? And then the other one was in the European Union proposals around AI is this question of risk analysis. They would require companies to talk about the risk posed by a particular AI model, risk of infringing privacy rights, risk of bias, and risk of copyright infringement. So they'd be asking the companies to assess this. Again, something I think would be very hard to do, but it would trigger the level of regulation that the EU would impose on a particular model. And I think with that, Anne, it's over to you to take
Okay.
us home.
All righty. So before the webinar started, we were chatting with the folks from TLA about the executive order that President Biden sent out this week, an executive order on artificial intelligence. And somebody asked me, what did it say? And I said, we're all going to work together and solve this thing. And I think that it was kind of what I expected to see, which was an order that attempted to balance some of these competing preoccupations, interests, and fears. How can various federal agencies help guarantee safety when people use artificial intelligence? How can they increase the reliability of these services? There's also strong concerns about competition and making sure that the U.S. is very prominent worldwide in commerce around AI, and also that everybody is happy about the intellectual property situation. That it is not a situation where there is a lot of perception of piracy of some sort, and there's also not so much lockdown around intellectual property rules that innovation doesn't happen. Most of that language in the executive order centers on patents and talks about consulting with the Copyright Office too. Copyright Office is in the middle of they just closed the comment period for a notice of inquiry about AI that apparently resulted in thousands and thousands of comments to the Copyright Office on the subject of copyright and AI, and I can just imagine what people have to say about patents if they have that much to say about copyright. So I think that really the thing that we can say is that this is on the radar of the current administration, and that they do feel that there needs to be a number of issues addressed, but the order talked about our values around the way we move forward commercially, more than the actual procedures that they're looking for. So I think they are, like everyone else, concerned, but not quite sure of the direction that'll be best for us. Kevin and I also, I think, believe that we have seen a good bit of the use of misleading AI generation, especially in the area of the political arena and news. And we certainly expect to see a lot more of that. It's a concern. It's a big concern. So, we talked a little bit about the EU is issuing guidelines around AI. And one of the things that the US will need to do, as they have had to do in the privacy area, is try to figure out when they want to comply with the EU's specifications in order to remain competitive internationally. And sometimes they want to, and sometimes they feel, I think, that their commercial interests prevail over whatever the rules in the EU are. I don't expect that to change at all either. Most of the tools that most people know of when they think about AI are owned by the large tech companies, and that seems unlikely to change in the near term. The more licensing restrictions that are put on the data used for training AI models, the more that the largest companies will be the people who lead the pack in this area, I think. I mentioned earlier that at our library, somebody came and told us, "Oh, but you're all going to lose your job soon," and I think that this is an issue with all of technology.
And
At the,
was that the president or the chancellor who came and told you that?
it was a faculty member,
Oh,
so
then, well,
I'm not. I mean, nobody went home and nobody started crying or anything, but there is always a displacement and disruption with as technology changes, um, and I think that is inevitable. Both of the big entertainment industry strikes recently have centered on AI concerns. The screenwriters wanted, and I think to some extent got some protections from AI generated content in the process of screenwriting. The Screen Actors Guild is extremely worried about the AI's ability to take over their names, likenesses, voices, and be used instead of the actual real people in the making of movies and TV shows. And one issue that I've seen a bit of, I'm sure you have too, Kevin, is that in this country we don't have a federal right of publicity. If you make your money by your name and likeness, there are state laws that may protect you from people who might co-opt your name and likeness, but there's nothing on the broader federal level. That's certainly something that might change. It and from the point of view of those industries, might be a welcome change for them.
yeah. Yeah, I think the Congressional Research Service just put out a short paper about the potential for AI to push Congress to pass a federal right of publicity law. But that last question, copyright has always been about competition, preventing unfair competition, but not stifling legitimate competition. And when we start talking about, okay, what if somebody's using AI to write a script for a TV show? What kind of competition is that? Is that the kind of competition that copyright should regulate, or that the government should regulate, whether it uses copyright or not? Or is it the kind of competition that we should let go because we generally think competition's a good thing?
Right. Stay tuned. So I wanted to, towards the end of this presentation, just make some comments about what I'm seeing on my campus. I'm currently the head of the University Copyright Committee, so we have had some impassioned and extremely interesting meetings this fall about AI. I've seen more faculty engagement around this than I think almost anything else we have ever worked on in the committee. Right before school started, the campus issued guidelines for teaching and learning around AI. A lot of the gist of the guidelines was you can use AI if your professor is okay with it and if you disclose its use. That left faculty with still with a lot of questions about how to apply the guidelines, how to know if AI had been used and not reported, how bad this is. And of course, I think as you often see in these situations, they were like, well, is this plagiarism? Is this copyright infringement? Is this nothing? And they still, I think in some ways the guidelines raised as many questions as they answered. There is an interest at our library on librarians becoming expert on developing prompts and helping patrons develop prompts, which I think is good. People, this is no news to any of us, have been using AI in the process of systematic reviews for quite a while. We're also in the process of considering guidelines for our repository around AI. Some people are having problems with bots crawling their repositories to get data. We haven't seen anything that was beyond our ability to handle, but I think, and there may be some things that AI will let us do with digital content that will be helpful, just in managing the repository and making it more usable. But I think it'll be later on this month that we start talking about this, and my guess is it's going to take more than one meeting to get a handle on even interim guidelines. I've received questions from instructional designers about the use of AI as they develop curriculum and multimedia models. For example, one person over the summer contacted me and said, I used a voice actor to put together some content that students use when they study for their biomed licensure. We need to change some of the information, and so we have the voice actor isn't available. We want to use voice cloning, AI voice cloning, to simulate his voice in parts of the module. What does the campus say about the ethics of this? And two, do you have a model contract that I can use with the voice actor? And I had to say, we've got nothing, at least at that point on the campus level, about the ethics. Was able to find some a model contract. That case, particular, the designer was planning to work with the voice actor instead of sort of without the voice actor's permission or understanding about the situation, but not all, I think, would do that or even think to do that. Our biomed faculty are quite concerned, as I said earlier, about the reliability issues, the provenance of data, the attribution questions. I've got these results, they look good, but how do I know they're good? Big concern. And the technology transfer people on our campus are going crazy. There's so much activity where different researchers and institutions are requesting data sets for payment or asking for them on some sort of quid pro quo basis. We have a data ownership policy that was in the process of being revised when all of this sort of hit hard on campus. And it may have to be revised before it's even, released to the public, just based on the enormous interest in getting access to data sets that they're experiencing, and having to develop guidelines and procedures for supplying or not supplying those data sets. A lot of super interesting activity going on.
I will just note that on my campus, which is much smaller than UNC Chapel Hill, within the past couple of weeks, I've helped negotiate for a faculty member for a data set from a large and well-known publisher for exactly this purpose, and was actually surprised at how prepared the vendor was for this kind of question. But so it's interesting that I think they're well prepared, but our campus mechanisms, the fact that I was the person helping them to negotiate this is actually a bad sign that we don't have the structures built on our campuses yet.
Yeah, and it's hit at the same time that the NIH data access policy changed, so that data has to be open, and that I think has set off a kind of a feeding frenzy in some ways. So for the last slide, I thought I would just give you some resources. These may not be the best resources in the whole world on AI, but they are the ones that we found useful and that we looked at. They're listed in the order of usefulness to me. James Kribbelman's article, which is still a preprint, not yet published anywhere except on his website, has been immensely helpful to both of us in learning more about the stages of AI generation, the supply chain, possible points of copyright implication throughout that chain. The Atlantic has been running a lot of articles on AI and copyright written for the layperson. They did a series on the Books 3 database, the one I spoke of that has a lot of contemporary books in it and is a pirated database. They include in one of these articles a link to an interface where you can put in the name of an author or title and see if that book is in Books 3. This is the subject of a number of the lawsuits I mentioned earlier. Matthew Sagg has also done a early and influential article on copyright safety for generative AI, and has been somebody who's been making the rounds, testifying before Congress during subcommittee hearings and so on. And I just thought I would mention at the end, the Library Copyright Alliance has some principles for copyright and AI. They are not very detailed, but I can't really fault them for that at this point. It's hard to know in the abstract where this is going to go, and to some degree what side libraries will take in some of these issues. And I think that is the end of our presentation.
Well, thank you. Oh my gosh, this was a lot. We still have a few minutes for questions. If you've got a question for Ann or Kevin, you can throw it into the chat. And hopefully we might have an answer.
I think the answers are likely to be maybe, and we'll see.
We'll see. Yeah.
One thing while we're looking or letting people type, I just want to reiterate how pretty much almost everything we've said suggests the relationship between assessing copyright and knowing as much as we can about how these models work.
Mm-hmm.
The way they're built determines an awful lot. And I think that the courts are going to run into those questions as they try to assess specific claims. Did we scare everybody away?
We may all be too stunned at the moment.
Yeah. I know the feeling.
Yeah.
Yeah. I would say one of the things I'm really interested at this point is to talk to our, to our research misconduct people on campus, the people who try to police and eradicate it, as opposed to the people who might be committing it, and just, get a sense of where they are seeing issues. And, if they can tell me anything confidentially, without implicating anybody in particular, and how faculty who suspect an AI issue with a student should proceed, really. I think there's a lot of desire to learn more about that process. That's what I'm seeing as one of my next steps.
Mm.
So Kimberly makes a statement and kind of a question. I'm thinking right now that there's not really any protective measures authors / creators can put in place to stop their work from being scraped. If we put in open repositories.
Well, I mean, I think some people are using the robots.txt file to stop scraping. That depends on the voluntary action of the scraper, I believe. And our developers for our repository have felt like that's enough for now. I don't know if they'll always feel like that.
Tracy asked, have you heard about content vendors incorporating AI in search features?
I think that's been happening for a long, long time. Whereas we've gotten this burst of interest in AI, I think that the use of AI in a lot of the products that we buy has been going on for a while. All the way back to, I'm going to date myself here, but Clippy. Do you remember the little thing that appeared to try and help you compose in early versions of Microsoft Word? And there have been AI tools. That's kind of why I raised the question of, is this just bigger and stronger? Are we just seeing a bigger, stronger version of Clippy and autocomplete? Or is there something really different here? I do think there's something really different here, but it is a continuum in terms of how these tools use it.
I have to say those tools really madden me. So they're either, I hope if we have to have them, I hope they get better.
Do you have any examples of the AI policy for higher education institutions or a verbiage that could go in the syllabi?
I'm going to go ahead and search for our material, and so somebody will say something while I'm doing that.
My campus has not yet adopted a policy other than to say it's up to the individual professors. I teach a class here, and this is an undergraduate institution that is largely about copyright rules and music. And what I say to my students is, when we're talking about copyright and when we're talking about the creation of music, we're talking about original expression. So let's start with, and that's what copyright protects, of course. So let's start with that idea of original expression and have a conversation about where you think AI falls. I've also told them if they use AI, and most of my assignments are structured in a way that they can't really. But if they do use AI, they have to disclose it. So I've made it an academic integrity issue, just like if they copy writings from other human beings and don't cite them. But that's very makeshift. I think probably by now Anne has something much more structured to tell us about.
Yeah, I put a link into our provost office has a page up about with AI guidance on it.
Ron asked, do you suggest any guides for submitting good prompts?
Repetition.
And I'm still on these. This is the employee side of the AI guides at UNC. I don't, other than, and that's a good question, but I don't have anything that's my go-to. Well, I might be wrong about that. Let me look for that too.
Okay, in the meantime, how would you suggest educators begin discussions with students on campus? Is there a recommended website or program for undergraduates exploring copyright for AI use?
I think those are just being developed. I follow a list of, the kind of centers for teaching and learning, those sorts of the folks who work in those sorts of offices. They do have an AI, a list about AI. I follow that. They talk a lot about producing those kinds of resources, but I think right now many of them are in process, and I don't think there's anything definitive out there.
Kathy is looking for a link to an ACRL webinar that she previously attended that went over those details. It covered some of the prompt writing advice. So
Prompt writing, okay. Yeah, I wasn't entirely being a smart aleck when I said repetition, because everything you hear about efforts to get really specific prompt libraries, that's an interesting idea. But everything you hear about how you get specific results from an AI model involves repeated efforts, reshaping your prompt, building on what the model has given you for your last prompt, and using that to shape the prompt to get whatever difference you want from it. Randomness, unpredictability, that is the problem we're fighting.
Thank you for the link, Kathy.
Yes.
We do have a live guide on using AI for systematic reviews. I don't think we have anything else up and running yet. But I'll go ahead and place that in the chat too. I know that, a lot of bigger campuses have, as we do. Our place is called the Center for Faculty Excellence, a center for to help faculty with their teaching issues. And they're actually, I think, running a section on teaching with AI right now. And I'm not there because I'm here. I am interested to see what they're saying and advising, though.
We are about out of time on this. If you would you put in the chat maybe some contact email or something in case people want to contact you directly for more information?
Yeah, always glad to talk to people. I'm sure that Kevin is as well.
Indeed, and I'm just putting my email address in there.
Yeah.
Thank you. I want to thank Julie Marshall and Kelly Mante from TLA for hosting this and getting us through this, and also to Alex Riggs and the program committee from CULD that worked really hard to put this on. Stay tuned. We have more good things on the way.
Thanks for inviting us.
Yes, thank you so much.
Appreciate it.
Thank you so much.
Thanks, everyone.